to our broadcast today. My name is Cindy Speaker. I have with me one of my regular guests, Miss Noelle Black of Gardberg and Kemmerly. Hi, Noelle.
Hi, Cindy. Hello. How are you?
I'm good.
Good.
Well, you have some really interesting information for us today on Social Security disability. Apparently, there's a relatively new ruling.
Yes.
How is it going to affect people, and what is it called?
Well, it is Social Security Ruling 183P, and it went into effect October 29th of 2018, and it is effective on any decisions that Social Security makes after that date. And it means that someone can be denied benefits if he or she does not follow the prescribed treatment that their doctors have ordered or said that they needed without good cause. That's the main gist of it.
Yeah. When you first hear that, it's a little scary for somebody that's applying for disability. We're going to get into it a little deeper, but first of all, is this all? It's all new. Is it completely new?
It's not completely new.
Okay.
Most of the information was there. I mean, you needed to follow your doctor's orders and do that kind of thing, but there was no procedures or specific outlines for how they should apply that rule, and now there is. So if you would be disabled regardless of if you follow the treatment, then it doesn't really apply. But if you would no longer be disabled should you follow that treatment, then there's certain guidelines for how they can deny someone benefits for that.
Okay. Now, what about doctors? Because a lot of people go to a lot of doctors. Can any doctor kind of make this an issue for the potential disabled person?
It has to be a treating physician that is actually treating you. Sometimes Social Security sends people to one-time examining doctors, and in the past, that examining doctor could say, well, if they were to have surgery, then they would no longer be disabled. But their actual doctor that treats them for whatever that surgery is needed for hasn't recommended surgery. So the rule does state that it does have to be a treating physician that makes the recommendation or the prescribed treatment, as they call it.
Well, Noelle, let's talk a little bit about lifestyle modifications that a doctor may recommend, because potentially the patient may not want to follow them. Are they still obligated? Is that part of a required compliance?
No, the new rulings say that they cannot enforce lifestyle modifications, which is something that was not stated before, and those include things like diet, exercise, and smoking cessation. Some of those things are a lot harder to do than you think they are, and they can't say now that if you were to lose 100 pounds, then you would no longer be disabled, or if you would follow this specific, whether a diabetic diet or heart diet or whatever, then it would improve your function. Or if someone has lung disorders, they can't say, well, if you quit smoking, because those are just guesses that should that happen, it may improve, but there's not something they can actually say would happen. So it doesn't include lifestyle modifications.
Okay. Let me ask you what you're seeing, because you deal with disability clients on a regular basis. How are you seeing this impact them? Is it a big problem, or?
There are some things. We haven't had any serious issues come up, but there are what they call good cause statements for not following that prescribed treatment. And basically this ruling lists 8 specific citations for why you can show good cause. And I'm going to look at my notes so I don't skip any of these. I don't have them all memorized. But the first one is religion. So if you have a specific religious belief that doesn't allow you to take certain medications or undergo certain surgeries, then you can just show that in your bylaws or in your documentation and prove that that's why you're not undergoing that specific prescribed treatment. The second one is cost. Now, this is something I do see a lot, that if someone needs an MRI to show what their problems are, or if someone needs surgery, even physical therapy, sometimes physical therapy can improve your function in certain areas if you were to go to that physical therapy. But a lot of our clients are without health insurance and without funds because they're not working. So they simply cannot afford those luxuries that we all take for granted that have insurance. The third one is incapacity, and I have had that happen. That's if you have a learning disabled person who sometimes they don't understand the consequences of not following that prescribed treatment. And I've actually had a doctor put in the records that this was a specific diabetic patient who was not taking their insulin properly because they simply could not read the orders that was on their insulin for how and when they should do it. And they didn't understand that. And it was like a consistent problem because of their intellectual functioning. They couldn't understand that.
Yeah.
The fourth one is medical disagreement. And I've also seen some clients who opted not to have surgeries done under this. They didn't actually have to show good cause. You know, the judges were not saying they were going to deny them, but I have had it come up where one client goes to see maybe a neurosurgeon who recommends a specific treatment. They want to get a second opinion. The second doctor says, well, I don't think that that's going to help your condition at all. So sometimes the best course of action is not to take action because you don't know what the outcome would really be. Number 5 is intense fear of surgery. And for some people with behavioral health issues, their anxiety is just too high. They have a lot of fear in doing any kind of surgery or following a certain treatment for that. Number 6, it kind of relates to number 5. It's prior history. And I've seen a lot of clients who come in who have what's called failed back surgery syndrome. They've had surgeries before in the past that just didn't help. It didn't, get rid of their pain. It didn't help them function at all. So they are apprehensive to undergo that again, even though the doctor has recommended that they have, another knee surgery or another back surgery, neck surgery, different things like that. Number 7 is the high risk of loss of life. And that comes with big events like transplants or open heart surgery. Doctors cannot give you a 100% guarantee in big, surgeries like that your body is going to accept the organ, that you're actually going to survive through the transplant, that you will survive open heart surgery. So, if it's that kind of surgery that has a high risk of loss of life or limb, then you don't have to undergo those. That's considered good cause. Number 8 is the risk of addiction to opioid treatment. And of course, that is new with the opioid epidemic that is going through our country now. They cannot force someone to take opioid treatment and say, if you took this opioid medication, then your pain would be controlled and therefore you'd be able to function in the workplace. They just cannot force people to do that. And then there are some other little things that may not fall underneath these 8, specific citations. And, that's just done on a case-to-case basis. The problem that I think, should we run into any of this with clients, is that we may not know that the judges are going to deny them because they're not following prescribed treatment until you get the decision. But that is something that, having an attorney's office help you with is going to be in your best interest.
Right. And on what how do they decide that they're not following the treatment based on doctor's notes?
Yeah, based on your doctor's notes, everything is based on your medical records, whether you're found disabled or not disabled. And if your doctor is putting in the records, I told this client to lose weight or have surgery or take this medication, and they're not for, X, Y, and Z reasons, it's kind of up to the judge's discretion whether they feel like the client is not following the rules and regulations under this new 18.3P.
Yeah. And as we know, there's already so many cases, so many claims that get denied. Right. Is this making it even worse?
It's just one more way to, decide that claimants are not disabled, to deny people the benefits that we all work hard for.
Yeah. So to individuals that are watching, if you need to file for disability, if you have filed, it really is going to benefit you to call an attorney's office and get involved, because someone like Noelle is going to be they're going to be able to help you avoid missing loose ends that could cause your claim to get denied. So I think it's really important to get an attorney's office involved.
Yes, I think it is too. These are a lot of rulings and regulations that the judge could put in their decision, and the average person would have no idea,
right?
What was that based on?
Exactly. Yeah. Well, Noelle, if someone wants to reach out to your firm, how can they do that?
They can call 251-343-1111 or 1-800-332-1529. Or they can reach us on the internet at www.gardberglaw.com, and we will be happy to help them out and see if we can get them the benefits that they deserve.
Excellent. Excellent. As always, thanks for your time today.
Thank you.
To those of you that are watching, either live or by replay, if you have questions or comments, feel free to leave them right on this page. Of course, you can call the firm. That's probably the fastest way to get help. But listen, thanks everybody for being with us today. We appreciate it. Bye.